right, welcome and good afternoon, everybody. I am glad that you are here. Before we get started, I want to kick off by sharing this. If you signed up for a webinar about divorce, custody support, or how to settle a family law issue without a long fight, then I think we probably already know a little about where you're at right now. You're probably carrying a lot. Um, Yeah, she's probably carrying a lot. Maybe you're lying awake worried about your kids, how all of this is going to affect them. Maybe you're scared about money and honestly afraid of what this is all going to cost you. Maybe you don't know what your spouse is going to do next, and that uncertainty that can be exhausting. Maybe part of you just wants this over, and another part is terrified that you're going to be giving up too much. And maybe underneath it all, you simply don't know what the next right step is. Now, if any of that sounds like you are in the right place. That's exactly why we have this conversation today. I'm not here to push anything. I'm not here to show you that court is not your only option, and that for a lot of families in your shoes, there's a calmer, more private, more affordable way through this. One thing before we dig in, everything I share today is general information. It's not legal advice for your specific situation because I don't know your facts yet. Your story is yours. The details, they matter. The timing matters. Your finances, your kids matter. So at the end of the day, I'm going to give you a way to sit down with a member of our team and talk through whether this path actually fits your life. Today's going to be a conversation, not a lecture. I'm going to ask you things along the way, and I want you to use the chat. What you're going through might be the exact same thing that somebody else on this call needs to hear. Keep an eye on the chat. I've got Charisma over here. She's going to be monitoring the chat and dropping some thought-provoking questions in there too. And stay with me all the way to the end. I've got something special for you that we don't just offer anywhere. And the people who stick around are the ones who walk away with the real next step instead of the same knot in their stomach that they showed up with. So, all right, we are going to go ahead and get started. Let me find my slides over here. Go ahead and get this presentation going. Fantastic. Okay. So here's what today is about. It's about how you can resolve your divorce or custody case without getting dragged through litigation. When you hear the word divorce, I bet you picture a courtroom, two lawyers arguing, a judge deciding your future, stress, money draining away, and no real control over any of it. And look, sometimes court is necessary. If you're dealing with a real safety issue, somebody's hiding money, or a spouse who flat out refuses to play fair, litigation may be exactly what you need. But here's the part that most people never get told. Your case probably does not have to start in a courtroom. There's another path where the two of you actually have a voice and where you work towards solutions instead of going to war. That path is mediation. Okay, so we're going to start off. I want you to drop some answers into the chat there. Have you ever actually stepped foot into a courtroom? Drop a yes or no in the chat for me. Go ahead and find my chat over here. We are getting a little bit in the chat, some echoing going on. All right. Hopefully that fixed it there. All right. No, nobody's not in court. Yes, jury duty. Okay. This is definitely different than jury duty. When we ask this question, a lot of people think, hey, here it's intimidating walking through those doors. We had a couple of people answer yes, even the one who said yes for jury duty. What did feel like walking into that courtroom feel to you? You don't have to share unless you want to, but was it a mix of fear, anxiety, feeling small? hey, what is this whole thing that's out of my hands? If that's you, know that that is completely normal. Courtrooms are not built to make you feel comfortable. They are there because they're formal and public. There are rules nobody explains to you. There are a dozen other cases on the calendar that morning, and you might just be sitting a few feet away from the person who you are in conflict with. And I love that answer. Yeah, they suck. Getting in, if you are not familiar with going into a courtroom, it sucks going into a courtroom. And when you go into a courtroom, going through a divorce, custody matter, this is not just some abstract legal matter. This is your kids, your home, your money, your future, your stability. Of course, it's going to feel heavy. So here's the question I want you to hold on to for the rest of our time together. If there was a way to settle big issues in your case while keeping the conflict down, keeping your private life private, spending far less and actually staying in control of the outcome, would that be worth the next hour of your attention today? Think about it. Okay, here's what the next hour looks like. Here's what is ahead. First, we're actually going to go through, I'm going to show you exactly what mediation is and how to tell, is it right for your situation? Then I'm going to walk you through what real mediation looks like, what it costs, how compared to a court battle, and why for a lot of families it ends up being a better choice. Then I'm going to show you how to prepare so that if you do go through mediation, you walk in ready and you can get the most out of it. And at the very end, I have a special offer for people who showed up today. It's genuinely valuable, and I'm going to explain exactly how to grab it. One heads up now so it doesn't catch you off guard later. The next step involves both of you, you and your spouse. So if you're here on your own today, that's completely fine. I'm going to show you how to bring your spouse up to speed so don't drift off before we get there. All right. I want to start off with a story because mediation is not really a legal process. It's a human one. We had a couple who honestly, they were doing pretty well. They had worked through custody. They had talked through the visitation. They had figured out support. They had even sorted out most of their property. Things were moving along. And then the whole thing ground to a halt over one small table. On paper, it was nothing. It was the last thing that you would expect a divorce to blow up over. But in that room, it became everything. He wanted it. She wanted it. The temperature went up and the tone changed. And all of that progress that they had been working on stopped. Now, picture that same fight in a court. The judge wants facts. What is this table worth? Who bought it? When? Is it community, separate property? Is there a legal reason why one of the two of you should get it? They're fair questions, but it completely misses the point of what's happening. In mediation, the mediator gets to do something a judge does not have time to do. Stop. Get curious. Instead of who gets the table, the mediator asks, what does that table mean? And that changed everything. For one of them, the table had memories. For the other, it represented a whole history together. It carried meaning that would never show up on a financial form. It was never really about furniture. It was about feeling seen. It was about not having your whole life together carved up like inventory. We'll go back a slide. Yes, it was the elephant table. Do you have an elephant table in your room? That's the kind of thing mediation can make room for, and a courtroom simply cannot. In a courtroom, there's no time for that. There's deadlines, rules of evidence, a packed calendar, and a judge with 10 other families to get through before lunch. Mediation, you get to slow down. You slow down long enough to ask what is really going on here. And once that happens, you get to find creative solutions that work for both of you. That's the difference in a nutshell. Court is about facts and deadlines. Mediation is about people, what actually matters to them, and finding something that works. And here's the thing, in family law, this happens constantly. The fight looks like it's about a weekend schedule, but it's really about being afraid of losing time with your kid. It looks about support, but it's really about being afraid you're not going to be financially okay. It looks about like it's about a piece of property, but it's really about wanting to feel respected on your way out the door. A good mediator helps you get what is actually driving the conflict. Get down to that, because that is the only way to solve things for good. Okay. Now that you've seen what mediation can look like, let me back up and answer the obvious question. What exactly is mediation? Let's spend a few minutes on that because I find most people have heard the word but have the wrong picture in their head. Maybe you think it means sitting in a courtroom being forced to compromise. Maybe you think it's signing away your rights. Maybe you think it only works if you and your spouse already agree on everything. Not true. Here's the real definition: mediation. Mediation is a structured process where a neutral professional helps the two of you communicate, get clear on the issues, understand your options, and work towards the agreement. That's it. That's high level. Let's dig into it. Most people assume that court is the only door, the only option that you have. That once things get hard, you go ahead, file papers, lawyer up, and go fight it out in front of a judge. And I get why people think that. Honestly, I want to be straight out with you something. I'm a litigator by training. Attorneys like me were taught to fight. We're trained to win the argument, to file the motion, to take it to the judge. I've handled a lot of contested cases over my career, and for a long time, it's just how I assumed that this is how things go. Litigation is where you need that pit bull, the shark. But somewhere along the way, I saw what mediation and a negotiated settlement could actually do for a family. And it changed how I think about how this all works. So when I tell you court is not always the answer, it's not a sales line. This is a litigator telling you there's often a better way. And most lawyers will never say that to you. Because here's what litigation does. It's built around positions. You file, they respond. You argue you're right, they argue they are right. The judge decides. It turns every disagreement into a battle. It can run your fear, your anxiety, and puts you in a win or lose mindset. The goal becomes beating the other person instead of solving the problem. Mediation flips that. Instead of, do I win? It asks, what needs to get solved? What are our options? That one shift changes the entire experience. Now, I want you to go ahead in the chat. Type 1 if you assumed court was basically the only way to get your divorce or your custody dispute settled. Type 2 if you already knew mediation was a good option. Okay, we've got some 2s, we've got some 1s. All right. Wherever you're starting from, the takeaway is going to be the same. You almost certainly have more options than you've been told. Now, if money's tight, you're probably thinking something else right now. Can we just do this ourselves? Download the forms, fill them out, skip the lawyers entirely? It's a fair question, so let me give you a straight answer. Yes, you can try. Some cases, well, they move perfectly fine that way. But here's what I see happen. When you go online, you download the forms, they're very generic. They don't know your situation. The courts reject paperwork all the time, being incomplete or filled out wrong. And now you're stuck redoing it. And the bigger risk is a do-it-yourself agreement. It could miss something, or it's not actually enforceable, or it can quietly fall apart later. And fixing a broken agreement after the fact almost always costs you more than it would have cost to do it right the first time. So the way I've seen it, doing it yourself is not really the cheap option. It just moves the bill to later with interest. Now, if the other person is coercive or controlling, if they're hiding money, refusing to put their cards on the table, or they're simply in denial that the divorce is even happening, then a do-it-yourself agreement is not going to hold. And you may need the protections that only come with representation. That is not a failure. That's just the right tool for that situation. And if it's you, the consultation at the end of this is exactly where we sort out which path is going to go ahead and protect you. So here's the real question to ask yourself, and it's the one that we're going to put on the screen. Is there enough mutual respect between the two of you to negotiate without each of you having a lawyer in your corner? If the answer is yes, mediation can work beautifully. If not, it's not failure. It just means you may need representation. And that's where we head on in discussing the consultation. Okay. What is a mediator? A mediator is a neutral party. They don't represent either side. This kind of trips people up every now and then. They're not on your side. They're not on your spouse's side. They're not there, I should say this. They're not there to represent anybody. They don't decide who wins or to punish anybody. They are not a judge. What they do is run the conversation. They help you name the issues. They explain how things generally work. They lay out your options. They guide the two of you towards a resolution you can both live with. And that neutrality, that's the whole point. The mediator can tell you, here's how the issue usually gets analyzed. Here's categories that we have to cover. Here's what other families in your spot have done. Here are the documents we're going to need. And here's what happens if you leave this unresolved. What they will not do is become anybody's lawyer. This is also why it matters that your mediator is an attorney mediator, not just anybody with a certificate. An attorney mediator understands the legal framework, the court process, and what would realistically happen if the case went in front of a judge. That keeps the whole conversation grounded in reality, so you're not making decisions based on guesses. And to protect you even further, most mediations, each of you can have your independent attorney review the final agreement before you sign. So you get a calmer process and a peace of mind. This is the part I love in mediation. You get the power to decide. The mediator just creates the conditions for the two of you to get there. The agreement is yours. Now, there's more than one type of mediation, so I want to go ahead and clear things up. One kind is actually court-connected mediation. If your case involves custody and visitation, the court may make you go through a court program before a judge rules on custody. That's usually focused just on the parenting piece. Private mediation, on the other hand, completely different animal. And this is what I'm talking about today. You can use it before things get heated, before they get litigated, while your case is pending, or even after a court fight has already started. It can happen in person, over Zoom. Ours, the way that we handle ours, they're not over Zoom. And you can use it for the whole case or for just one stubborn issue. So you might use it to handle your entire divorce, parenting, support, property, debts, all the final paperwork. Or you might just use it to settle one thing, like a holiday schedule or support change the two of you cannot agree upon. The flexibility, that's the point. You get to slow down, prepare, actually understand what you're deciding, and work through it like an organized way instead of reacting to the next court deadline. Okay, is mediation right for you? Let me describe the cases it tends to fit and see if you recognize yourself. If you want to stay in control of your own outcome, this is for you. When you go to court, you're handing your family to the judge. The judge, they'll do their best, but they don't know your kid's bedtime routine, your work schedule, your holiday traditions, or your finances the way that you do. In mediation, you build a plan around your actual life. If you're a parent and you want to protect your kids from the conflict, this is for you. Your children do not need you to agree on everything, but they do need you to be open-minded, ready to discuss options for them. Mediation keeps the focus on what is important instead of every old frustration. If the cost and stress of a court war scare you, this is for you. Litigation gets expensive fast. Filings, court appearances, discovery, declarations, hearings, preparation, and conflict, all on repeat. We'll walk through about the real costs in about a minute, because for the most people, this is the number one reason they go looking for another way. And if your privacy matters to you, mediation is for you. Your financing, your parenting struggles, your marriage, none of that belongs in a public record if you can avoid it. Mediation keeps things private. Okay, I'm being honest about about when mediation is not the answer, because I'd rather you trust me than let me think that I'm overselling you. If there is a real safety risk, if somebody is being controlling or coercive, if assets are being hidden, if your spouse simply will not participate honestly, the mediation may not be the right move right now. You should not have to figure that out alone. This is exactly the thing that we need to sort out at the end when we talk about the consultation. Now, we're dropping in the Q&A. I want you to type which of these matter most for you. Is it A for privacy, B for control, C for less conflict, or D, you can actually get a faster resolution? Okay, got one, all of the above. I like that. Faster resolution, control, privacy. Okay. A couple more answers coming in here. 1, 2, and 3. Less conflict, fantastic. Whether you just thought of it or hold on to it, because that is the thing that should drive you to make the next choice. Most people want more than one. And the nice thing is mediation, it can give you all of those. Okay. Let's talk about what mediation can resolve. Sometimes people will assume it's only the easy stuff. It's not. Your parenting plan, legal custody, physical custody, the regular schedule, holidays, vacations, exchanges, who makes school and medical decisions, all of it. Child support, the income picture, guideline support, add-ons like childcare, medical and how it actually gets paid, spousal support, temporary, long-term, how it lasts, step downs, and creative structures that are going to fit your real numbers. It can address property, the house, the bank accounts, the cars, the retirement, the debts, personal property, a business, all of it, and everything in between. Sometimes you're not ready to settle everything at once. That's perfectly fine. Mediation can set up temporary agreements. Who pays what, who stays where, how parenting works for now, while you sort out the rest. Here's the key thing that I want you to hear. Mediation does not skip the hard legal issues. It deals with every single thing that a court would. The difference is how. In court, each issue gets fought over, back and forth, you versus them. Mediation, those exact same issues get worked through in negotiation. Somebody guiding that conversation. It also stays productive instead of turning into a courtroom brawl. Same issues, completely different room. Which one of these stresses, go ahead and drop this in the chat here. Which one of these stresses you out the most? We're looking at parenting issues, support, property, debt, communication. And again, it could be more than one. These are the issues that mediation is going to address. These are the issues that you can address in court, but again, with mediation, a lot less conflict, a lot more control, and a lot quicker resolution too. Yes. All right. Most communications, or excuse me, most cases, they're going to have more than one. And that's the value of a good process. It separates the issues out. So the whole thing stops feeling like one giant crushing problem. Okay. I want to put mediation and litigation side by side because this is where it gets real for most people. The path that you pick affects what you spend, how long it takes, how private it stays, how much stress you carry, and what your relationship looks like when the dust settles. I want to walk you through what litigation actually looks like so it's not a mystery. Usually starts finding an attorney, preparing the court paperwork, filing the documents with the court, getting your first hearing date, serving the paperwork, attending your first court hearing, and there could be additional hearings if you don't resolve things at that first hearing. Then comes the financial disclosures, the discovery, the back and forth negotiations, the motions to move things along. Then you get to a mandatory settlement conference and eventually maybe a trial. A contested case that goes all the way can take more than a year, sometimes two. Some go faster, some slower. But the point is, once you're in it, it can drag. And the process itself feeds the fire. The day your spouse gets served, it feels like an attack, even when the filing was routine. When declarations get written, people reach for the worst moments of their marriage. When hearings get set, both sides gear up to win. None of that makes settling easier. It makes it harder. Litigation has its place. Sometimes you need it. But what you actually want is less conflict, a working relationship with your co-parent, your privacy intact, and a resolution that costs you a fraction of a court fight, then you owe it to yourself to look hard at mediation first. For most families, that worry right there is the whole reason that they go looking for a better way. Now, really quick, what it actually feels like to be in court. We talked about going into court earlier, the anxiety, the fear, but there's two types of hearings that you actually come across in court. You don't jump immediately to that to a trial right off the bat. Now, we call the first one a short cause hearing. This is where you're in your courtroom with about 10, 20 other cases waiting their turn. Sometimes it can be over video, and your moment is brief. The arguments, they're quick. The judge asks for a few fast questions and then decides in very little time with very little information. And when the thing on the line is your kids, your home, that can feel maddening. A trial, completely different beast. It can stretch over days, even weeks. Witnesses, testimony, exhibits, objection, the works. The judge might take it all home and hand down a decision a week later. Sometimes that level of formality, it can be genuinely necessary, but be honest with yourself. You probably don't want a public battle. You want answers. You want to know where your kids will be going next week. Who's paying the mortgage? How long is support going to be? Whether you can finally exhale and move forward. Mediation is built to give you those answers directly. All right. Let's go through the steps of mediation. Step one, find your mediator. You want somebody who knows family law, understands conflict, stays genuinely neutral, and keeps things moving. Step two, financial and asset disclosures. Good decisions need real information. So this income, expenses, assets, debts, and documents behind them. The more honest and prepared you both are, the better this works. Step three, your wish list. It's not about demanding everything. It's about getting clear on what you actually want, what you are worried about, whether you might bend, and what a good outcome it would even look like for you. Step four, preparation and review. This is where the attorney mediator does the homework before you ever sit down with them, getting clear on what needs to be resolved and what matters most to each of you. Here's something that surprises a lot of people. You and your spouse may already be closer to an agreement than you realize. And a prepared mediator, well, they can spot that and help you close the gap fast. All right, you start your mediation session. This is where it gets real. You both sit down with the mediator. You name the big issues, you talk priorities, and you start finding the first points of agreement. You don't resolve it then, you come back to a second session, and even more if you need them. Some cases wrap up quickly, others take a little bit longer, depending on how complex things are and how far apart you start. Then you reach an agreement. That might be a full agreement or a partial one. And partial still counts because every issue that you settle is one less thing to fight about. Step 8, court documents get prepared. You still have to file with the court. But this time, instead of being adversary, the court documents start out with your agreement instead of getting ready for a fight. Well, then you sign everything, it gets filed with the court. And here's the timeline that gets everybody's attention. We aim to wrap up the whole thing, the paperwork and all, in a matter of weeks. Not a year or more like a litigated case can take. Now, every case is different, so I'm not going to promise you a date. But weeks versus a year, that kind of difference can change your life. A lot of people feel calmer just seeing it laid out like that. Half of what makes divorce so overwhelming is knowing what comes next. Mediation gives the whole sequence something that you can actually follow. Okay, let's dive into that mediation session. These days, a lot of them, they're going to happen over Zoom, like ours, which honestly takes a lot of pressure off. No courthouse, no travel, no sitting across the table from your spouse before you're ready. It usually starts with the mediator setting the ground rules, how this stays neutral, how it stays confidential, what you're trying to get done, and how the conversation is going to flow. Then, mediator listens to both of you. That part matters. Mediation is not about silencing anybody. It's about making sure you actually get heard in a structured way, maybe for the first time in this whole process. Then you take one issue at a time. And that is a bigger deal than it sounds. When you're in conflict, everything feels intertwined. Parenting leads into money. Money leads into the house. The house bleeds into old resentment. Mediation pulls those apart so you can breathe. Let me give you a real picture of how that flow works. Say you start on a parenting schedule and it's going fine. Then you hit the house. Suddenly it gets tense. Voices tighten. Nobody is budging. A good mediator does not force it. They set the house aside for a bit. Move on to something else, something more workable, like how to split a few accounts. You get a couple of wins, the temperature drops, and momentum builds. Then you circle back around to the house, and you're coming at it from a calmer perspective. And you often realize it was tangled up with something else all along, like who keeps the kids in their school. That back and forth, that freedom to set something down and pick it up later, it's something a courtroom calendar will never give you. The conversational nature of mediation is exactly what lets ideas and solutions actually surface. Breaks are part of it too. In a courtroom, you're rushed. Courtroom calendar, you got to keep going. In mediation, you can pause, gather yourself, let the emotions settle, and come back when you're ready. And the most powerful tool in the room, it's a simple one. The mediator asks why, not just what. You say, I want the house. Why? Because I want the kids to stay in their school. And just like that, the conversation opens up because maybe there's more than one way to keep them in that school. You say, I want every weekend. Why? Because your work eats your weekdays and you're scared of losing the relationship you have with your kid. Now, we're not fighting about weekends anymore. We're protecting your time with your child. This is where solutions start. Finish this sentence for yourself. You can put it in the chat or just in your head. What I really want out of all of this is take a moment to think about that. That sentence is everything. Mediation works best when you know what you truly need, not just what you're reaching to in the heat of the moment. Now you've seen both paths, the courtroom and mediation table. So let me put the thing on the table that matters most to a lot of you, especially if money is tight, which is what does this actually cost? Litigation's typically billed by the hour, and you don't control the clock. Every email, every phone call, every motion, every reaction from the other side, it lands on your bill. The total financial impact often isn't known until everything is finalized. There's an old joke. Some say marriage is 50-50, but divorce is 50,000. Okay, maybe only attorneys think that that's funny, but it's not exact. No, it's not. But it just really sticks for a reason. Because anybody who's been through a litigated divorce knows it captures something painfully true about what a court fight can cost you. Mediation is the opposite way. Instead of an open-ended meter, it's one flat, predictable fee, agreed upon upfront, that covers the process for both of you. And you know what you're walking into before your start. It does not balloon every time your spouse fires off an angry email. Now, I just be transparent here, just to let you know, so you're not wondering, hey, he's going to keep this till the end. What's ours cost? Our mediation, our attorney mediation, it's going to start out at $8,500. And for a family watching every dollar, that predictability, what we lay out, it's this much. It's not a small thing. It's the difference between dreading the next invoice and knowing exactly where you stand from day one. Okay, why mediation can be better for you. First, you stay in control. In court, the judge decides. In mediation, you decide. Not everything goes your way. It's not how it works, but you have a real hand in building the outcome. And that means the result actually fits your life. A judge hands you a standard schedule. In mediation, you shape it around your work, your kids, their school, their activities, your holidays. The real details a judge will never know. Second, you lower the conflict. The whole process is built around solving problems, not attacking the other parent. And it's huge. That's huge because once your divorce ends, it ends the marriage, but it does not end the relationship as co-parents. You're going to be in the same room at graduations, weddings, sick days, and 1,000 text messages about logistics. A process that torches communication can cost you years. A process that that protects it pays you back for years. Third, you're going to keep your privacy. And there's a legal layer here that really matters. Your finances and your personal life stay out of the public record. On top of that, what you say in mediation is generally confidential and cannot be used against you later in court. That protection is exactly what lets you both speak openly enough to actually solve things. And the mediator can meet with you privately. It's called a caucus, and only share what you give permission to share. Fourth, mediation is going to cost you far less, not because anybody waves a wand, but because you are not paying for repeated court battles. Fewer hearings, less discovery warfare, more focused conversations. One predictable fee instead of a meter that never stops running. Fifth, it's faster. When you both show up in good faith, when you're both ready to negotiate, you're not waiting on court dates, and you're grinding through hearing after hearing. You move your case forward. Sixth, maybe the most overlooked one. It sets you up for an easier future. People actually follow agreements they helped build. When the two of you create a plan instead of a judge forcing one on you, there are fewer fights down the road. Fewer trips back to court to change things. And that saves you money and stress for years, not just today. There's no wrong answers. Different families need different things. The beauty of mediation is that it can give several of these things at the same time. I want to clear up a common misunderstanding. Misunderstanding. Yeah. Okay. Misconception, a common misconception. People think that they have to already agree for mediation to work. They go, mediation sounds great, but my spouse and I cannot agree on everything. Well, they think that mediation is going to fail because of that. But the reality is, that's the entire reason mediation exists. You don't need to agree on everything. What you need is to have good communication. Those are very difficult things. You do not have to get along. You do not have to trust each other completely. You do not have to have everything or even anything figured out before you start. You just have to be willing to be honest, share information, listen, consider option, and work towards a resolution. And let's be real, mediation is not magic. It cannot force someone to be reasonable. It cannot fix every dynamic, and it cannot replace legal protections when you truly need it. But when you're both willing to show up in good faith, even angry, even frustrated, even miles apart, it can absolutely move you forward. And here's something that should take some pressure off of your shoulders. Choosing mediation does not lock you in. If it turns out it's not working for your situation, you still have every other option open to you, including court. You're not signing away anything by trying the calmer, cheaper option first. So think about your own situation. Think about what good faith negotiation looks like to you. Think about sharing that financial information, listening before you react, and being honest about what you can afford. Does mediation sound like it is going to help you out with the answers to these questions? Does it give you clarity? Does mediation give you the clarity that is going to help your future? Getting clear on these answers really helps you figure out, is mediation the solution for you? Now, mediation versus litigation. Litigation, again, it's going to ask who wins. Mediation asks what works. Litigation puts your life, your future in the judge's hands. Mediation keeps it in yours. And don't mistake it for being soft. Mediation can be hard. You're going to have tough conversations, face real financial facts, and make real compromises. But the goal is different. In court, you're trying to convince a judge you should win. In mediation, you're building something you can both actually live with. And that matters more in family law than almost anywhere else, because this is not a business lawsuit where you walk away and never see the other side again. If you share kids, you're connected for years. So the real question is, it's not what can I get? It's what am I going to let my family, how is my family going to function once this is over? That shift from winning to working, it's the heart of everything that I'm going over today. Okay. Before we move on to part 3, I got a special gift for you, because the question I get more and more is, how do I even know if mediation is right? This mediation resource that we've got, it's going to walk you through it. Can the both of you participate safely? Are you both willing to put the financial cards on the table? What actually needs to get resolved? Are there court deadlines bearing down on you? What are the real priorities? Where could you be flexible? What should you be asking before you even sit down? It's not going to turn you into an expert, but it's going to help you show up prepared to know that mediation is going to actually work. Now, to get this resource, what I want you to do, scan that QR code, or got Charisma just dropped the link in the chat. This is a completely free resource. It is my gift to you. And it's going to help you look at your own situation clearly and figure out the path that's right for you. So I'm going to take a moment, leave this up there. If you're on a computer, scan the QR code. If you're watching this on your phone, on your tablet, take a screenshot. You're going to go ahead and have that QR code for later to go ahead and download it. All right, let's move on to part 3. We'll get back to that. I'll put that up later. But part 3, I'm going to show you how to prepare for mediation, because this is where it can get tilt the odds in your favor. And here's where the mindset I want you to carry into it. You're not preparing to argue better. You're preparing to solve better. First, get clear on your goals. And I mean practically, not just emotionally. Do you need a parenting schedule nailed down? Do you need support sorted out? Do you need to know what happens with the house? Do you need some temporary stability while you figure out the rest? Second, know what's your priority. Everything cannot be the most important thing. When it's all a top priority, you can't negotiate. So decide ahead of time what actually truly matters to you. Maybe in parenting, it's the school nightly stability. Maybe it's the holidays. Maybe it's property, keeping the house, or getting out of debt, or protecting your retirement. Third, gather your financial information. Income, expenses, accounts, retirements, debts, the mortgage, car values, tax returns. Mediation runs on real numbers, not guesses. And the prepared person always has the advantage. Fourth, think through your parenting concerns ahead of time. Schedules, schools, exchanges, communication, healthcare, activities, holidays, and how the two of you are going to make decisions down the road. Fifth, be ready to listen. Listening does not mean agreeing. It just means understanding the other side well enough to respond in a way that actually moves things forward. 6, this is the hard one. You gotta stay focused on your future. Divorce, it's going to pull you backward. It pulls you into who did what, who's to blame. Some of that history matters, but the process works best when you keep aiming at what happens next. How do we divide this? How do we take care of the kids? How do we untangle our finances? How do we build a plan that holds? Which of these would be hardest for you? Setting your goals, your priorities, your financial information, parenting concerns, listening, or even staying focused on the future. You can drop it in the chat, drop your answer in the chat, or you can keep it to yourself. But these things, what is going to be the hardest for you to go ahead and move forward? Whatever you just pick, it's a perfect thing to talk through in the consultation that we're going to talk about at the end. All right, I want to get a little more concrete, not just high level. On income and expenses, you're going to want a clear picture of what comes in and out. Your wages, any business income, your regular expenses, childcare, insurance, and housing. Property and debts, get the basics together, your accounts, your retirements, vehicles, real estate, credit cards, and loans. Parenting schedule, think about what would actually work for your kids given school, the distance between your homes, your work, and their ages. Non-negotiables, be honest with yourself. A non-negotiable should be something that truly matters, not just a preference. If everything is non-negotiable, you make this so much harder on yourself. And finally, where can you flex? This is powerful. Maybe you're firm on keeping the kids in their school, but flexible on certain holidays. Maybe you're firm on protecting your retirement, but flexible on how the rest gets split. Flexibility is not a weakness. It's usually the thing that unlocks a creative solution you'd never get in front of a judge. Oops. Okay. If you're taking one thing from today, make it this. You're not preparing to argue better. You're not preparing, or excuse me, you are preparing to solve things better. Those two are completely different mindsets. Arguing better means collecting ammunition, focusing on the flaws, trying to prove you're right and they are wrong. Solving better means gathering information, getting clear on what matters, understanding your options, and aiming at the outcome you actually want. And if there's a real difference between a position and an outcome, a position is I want the house. The outcome underneath it is I want the house, stability, and a fair financial result. A position is I want every weekend. The outcome, I want consistent, meaningful time with my kids. A position is I'm not paying support. The outcome is I need something fair that I can actually afford. When you start aiming at outcomes instead of digging into positions, suddenly there's more ways to win. It's exactly where mediation shines. All right, bring it all home for you. 1, mediation lowers the conflict. It gives you structure for the hard conversations and a neutral guide to help keep you on track. 2, it saves you real time and money. One predictable fee instead of an open-ended bill, often wrapped up in weeks instead of a year or more in court. 3, it works for a lot of families. Not every family, not every case, but a lot of people in your exact situation come out better with a process that's private, flexible, affordable, and focused on solutions. 4, preparation changes everything. The clearer you are on your goals, your priorities, your numbers, and where you can bend, well, this is going to go better. This is where things go better. 5, it's simply a more thoughtful way, because this is not just about ending a marriage on paper. It's about building your next chapter. If you're a parent, it's about giving your kids a stable foundation. If you're dividing a life, it's about financial clarity and real closure. Court has its place, but mediation gives you a chance to come out with your dignity, your privacy, and your control intact. Okay, going back to that mediation readiness resource. Go ahead, scan that. So right before I get to that special offer, I'm going to give you one more chance to grab this free resource in case you missed it before. Scan that QR code, take the screenshot, use it to ask yourself these questions. What truly needs to be resolved? What information am I missing? What's my real goals here? What am I actually afraid of? What would make me feel ready? What should I be asking before I choose mediation? All right, we're coming to the end of our hour and you stuck around. So we're going to get to our special offer. I want to start with something I genuinely mean. You showed up. You took the time out of a schedule that is already stretched thin. You spent the past hour here learning how to handle one of the hardest things that a family can go through. This matters to me. We understand your time is valuable. Time is money, and you spent your hour with us. So I want to reward you for that. Here's how. Normally, every mediation we handle carries an administrative cost. It's the credit card processing, the postage, the paper, the staff time that it takes to move your case through our office. For our firm, it runs around $500. And it's a real cost we usually have to pass along. But because you're here today, we're going to cover that. We're going to eat that administrative cost ourselves, so it never lands on you. In plain terms, that's $500 off your mediation. Your flat fee that I mentioned before, $8,500, it's only going to come down to $80,000, or not $80,000, wow, to $8,000. That's both of you combined. So if one of you is paying $4,000, the other's paying $4,000, it's still less than each of you going and getting an attorney. This is the value that we're looking to help you move forward. This is our way of saying that your time is worth something, and that betting on yourself by being here today actually pays you back. Now, one string attached, of course. For us to absorb that cost, you need to retain our firm by Tuesday, September 15th. Okay. That is it's about 3 weeks from today. After that, the administrative cost goes back to being part of the fee. Now, before anybody signs anything, we want to make sure that mediation is genuinely the right fit for you, because it's not right for everybody. So your first step is to sign up for a free consultation with one of our client engagement specialists. It's not a sales pitch. And it's not anybody trying to talk you into anything. It's a straightforward conversation where they walk you through a series of questions about your situation to figure out, honestly, whether mediation makes sense for you. Here's the thing that differs about this consultation, and I want to be very clear about it so nobody books the wrong way. Both you and your spouse need to be on the call. That's not us being difficult. It's the whole point of mediation. Everything we talked about today, the neutral mediator, the flat fee that covers the both of you, the agreement that you build together, none of it works if only one person's in the room. So the consultation works the same way. Both of you together on one call. So that may put you in one of two groups right now. I want to speak to each of you. Group one, your spouse is already on the same page. Maybe they're sitting next to you right now, or they're even already on this, they're also on this webinar. Or you may have already talked about it and you both know mediation is a calmer way through this. If that's you, don't wait. Book the consultation. We're going to show you how to in a second. While it's fresh, while we're talking about it, pick a time that's going to work for both of you, get it on the calendar, and you're on track to have it handled. And again, that administrative cost is going to be covered if you retain by September 15th. Now, group two, you're here on your own and your spouse is not there yet. Maybe they don't know you're watching this. Maybe they think mediation means giving something up. Maybe the two of you are barely talking right now. If that's you, I don't want you booking a call your spouse is not going to show up for. Here's what I want you to do instead. Following this webinar, you're going to get two things from us by email. First, a one-page guide written for them, not for you. Second, the recording of this webinar in its entirety, so your spouse can actually watch exactly what you watched, and they're at their own pace without you having to translate or explain any of it. And I want to be clear about what this is. You've taken the last hour and you know it's not a sales piece. This is neutral information. What mediation actually is, what it's not, the two paths side by side. And honestly, the situations where mediation is the wrong idea and they should, you might have to have your own attorneys instead. I even say that. You remember that from earlier. Now, share both of these with your spouse who isn't here. That resource we're going to send out to you, as well as this webinar. Let the material do the talking so you don't have to. And once they've seen it and they're willing to sit down and have one conversation, you book that consult together. The September 15th deadline still applies, which is exactly why I'm telling you to send it, have that conversation with them the day you get the email from us. Because if you delay, not next week, you're going to say, well, we can go ahead and wait. We can wait. 3 weeks is plenty of time to watch that recording, to have them read this guide, and have one honest conversation. This is why we don't want you to put off. When people leave a webinar like this, they tell themselves, I'll deal with it later. But later has a way of becoming next week, lying awake. Another week of tension in the house. Another week of not knowing. Another week of that knot in your stomach about money, the kids, the house, and what they might do next. And in this case, later also means we can no longer cover that cost. So you definitely want to go ahead and retain by September 15th. Getting that call on the calendar gives you a next step. It does not obligate you to do anything. It does not force a decision. It just gives the two of you clarity. And clarity, for most people, is the first time they breathe easier in weeks. So if anything I said today landed, if some part of you is thinking, I want a calmer path, I want to avoid a court war, I want to keep this affordable, I want to know if this could work for us, then this is your moment. If your spouse is ready, book the call now. If they're not, watch for that email. We're going to and share it with them as soon as it lands. Now, how do you book your consultation? Here's what you do. Scan the QR code right on your screen. We've also dropped the link in the chat. Scan the QR code. You can book it right away there. Click the link. It'll take you to a scheduling page. Or give us a call, 951-309-9358. When you book, you're going to be asked for some information. And we want to go ahead and make sure both of you are in the call. So we're going to get both of your information. If your spouse is ready, if you're both ready, do it now while it's fresh. Open the phone, scan that QR code, click the link. As soon as we're done with the webinar, give us a call. If you're not ready, your job today is simpler. Take a screenshot, save that QR code, save that phone number. You're going to get that guide, you're going to get the recording, and you're going to share it with them. And then once you're ready, book it together. I'll leave this up for a minute so everybody can get it. Again, that phone number, if you're just listening to this, 951-309-9358. We've got the link in the chat. Scan that QR code. Okay. All right. It is now time. I'm going to take some Q&A. Now, remember, I can only give general information here, but I cannot give you legal advice about your specific case in a group setting like this. So if your question is really specific to you, it's the perfect reason to grab that free consultation. And honestly, the specific questions are exactly the ones that deserve a real one-on-one attention. That's why I keep nudging you. Book before you go. I'm going to go back. There you go. Book before you go. Get that recording in front of your spouse. If mediation fits, the two of you will leave that call knowing your next step. If it doesn't, well, you're going to be a little bit clearer about why you came in. Either way, you're going to stop being stuck. One more thing about today, if you have any feedback for us, scan that QR code, fill out a quick little form, and it genuinely helps me make these better for families going through this. So with that, I'm going to find my Q&A tab. Where's my Q&A tab? Do we have anything in Q&A? It's in the chat. We've got a couple things in the chat. Okay, first one. Do I have to be under Riverside County or can I be in another county to retain your services? For us, We can handle mediations all over the state of California. We are California attorneys, so we're well versed in California law, how certain things are going to go ahead and assist you resolve things within the parameters of the law, and really be able to help get documents filed in your local courthouse. So no, not just Riverside County. It can be anywhere, all over the state. Other questions in the chat? We have a queuing. Okay, are you under oath during mediation? One of us is not very honest. So no, when you go into mediation, you're not sworn in. You go to court, courtroom assistant or the clerk is going to go ahead and swear you in that you're going to tell the truth, nothing but the truth, so help you God. Mediation, you have to come with a good faith belief that the other side is going to negotiate openly and willing to participate. And if they're not very honest, I mean, it may not have a bearing on what the ultimate outcome is going to be. Now, keep in mind, the mediator is not there to measure the veracity of statements made by somebody. They are there to help guide the conversation. And if somebody's not being honest, well, you can call them out on it. Say, you know what? That statement they said is really not true. We're not going to argue about it, but here's my position. Here's why I'm saying it is not the actual truth and how it should be considered. Okay. How do I know that your office will work in ways for me that are beneficial for me, not just my husband? He said he doesn't want lawyers and says that he trusts that I will be reasonable. My problem is that I don't know what is reasonable, and he tends to make decisions that benefit him. Okay. That goes back to the neutrality of the mediator. Okay. The mediator is not there to take sides, and our mediator does not take sides. The mediator is going to go ahead and pull information. Remember, ask why this matters. Not what's the legal reasoning behind it. Why does this matter? How can we go ahead and try and come up with a resolution? Now, again, mediation is not your only option. You go through mediation, you don't come up with a resolution on everything, that's perfectly fine. If you don't feel that you are getting your voice heard, you don't have to agree. But our office, completely neutral. That's why the attorney mediator is there, is to help move the conversation along, help guide towards a resolution. If there are multiple sessions of mediation and there's no agreement, okay, are there multiple sessions? Yes. Okay. We find that 2-3 hour sessions, this is what we built in, is typically enough to be able to resolve the issues in a divorce case because you are there going through everything. Now, if it doesn't resolve in that 6-hour time period, more sessions can be added on, but it's additional cost, of course. But we want to make sure that there is enough time for everybody to be heard. There's no rush to get through everything. But yes, we find that the 2-3 hour sessions or 6 hours of time is enough to go ahead and dig deep into the issues. Okay. Fees are paid upon retaining. In addition to the 2-3 hour sessions, what is included? Okay, what else is included in our cost? Preparation. As soon as you go ahead and retain our office, we're going to send you your homework. Okay. That's where you're going to put together all of your financial information. I talked about it in the process. You go ahead, put together your financial information, you put together your wish list. You both do that independently. That comes to the mediator. The mediator is going to review everything. And at that time, you could actually, if you're doing this independently, the mediator could look at these and go, oh, they're actually pretty close on some agreements. Those are the things we might want to tackle first. You go through the mediation, you come up with an agreement, then we prepare the paperwork. Prepare your judgment, get signatures, and we'll file everything with the court. So it's basically beginning to end is included in that fee. Okay. Stocks and retirement accounts, how do we figure them out? Well, we don't actually figure anything out. That is, the mediator there is to help come up with solutions. Mediator is going to say, well, in California, this is how we can go ahead and this is typically how retirement accounts are divided up, but we're open to a discussion. We're open to solutions. Scanning the chat here. Charisma, do we have any other questions? No? All right. Well, I have kept you longer than the hour. So we'll go ahead and end with this. If you we got one more. Do we set child support? Yes, that is definitely one of the things that can be a child support can be addressed in mediation. You can address everything that you would address in court through mediation. Okay? If you remember one thing, let it be this. You have options beyond a courtroom battle. There's a more private, more affordable, more human way through this for a lot of families. And it might be right for yours. If you're ready to find out, we had that QR code before. Click the link in the chat or give us a call, 951-309-9358. Book your consultation with our client engagement specialist. Both of you on the call, one conversation, and you're each going to walk away knowing what the next step is. And if your spouse isn't there yet, watch for that email, send them the recording and the guide, and then book together and make sure you retain before September 15th, because we want to reward you for your time being here. Thank you again, and I would genuinely love to help you find your next step.